Ira Reiner handed the case to John Phillips, Deputy District Attorney and author of Sign of the Cross.
The trial itself wound up being of 4 individuals, including Tom Metzger, Stanley Wittick, and 2 other individuals that were really non-players. It was with an intent that we will prove was to intimidate, to provoke, to incite terror in others.
Phillips' challenge was to show that the defendants had stepped across the boundaries of the First Amendment's right to free speech.
Clearly there were First Amendment protections which theoretically extended to the activity that the Klan was conducting that night. Our strategy was to show that there was a consistent pattern defining the intent of the Klan to incite terror in the neighborhood and to provoke a violent reaction.
Your Honor, I'd like to call Mr. Metzger to the stand, please.
But there were plenty of surprises as the defense began their case.
What was your role the night of the wedding?
Tom Metzger washed his hands of the other defendants. He didn't claim the same First Amendment grounds that they were claiming. Tom Metzger claimed that he was there solely as a reporter who was going to do a story on what the others were doing.
One more question, Your Honor.
Thank you.
Prosecutor Phillips did not buy Metzger's story.
What was important in proving the case against Mr. Metzger was to follow what his course of conduct had been throughout the state of California over a number of years, going from county to county, organizing cross-burning ceremonies, as they call it, and instigating violence, in some instances very brutal violence.
While Metzger avoided the spotlight on Lake's tape, the prosecution still managed to use it against him.
So this barbecue was really a ruse for the cross-burning, wasn't it? Your ruse.
Yes, if you say so.
It's not if I say so, sir. The one thing we had to prove the charges against the Klan, it was really to establish a pattern of terror that they were bringing into various neighborhoods from the Mexican border on up to Sacramento.
To the jury.
Thing that these people are trying to say here, the witnesses that they've presented, that the neighboring residents did not know what was going on. That's absolute nonsense. And this brings me to the last witness I want to talk about. This is, in a lot of respects, what this case is all about. Yes, we have the fire code provisions, and that's the basis for the violations of 2 laws. We have another charge, which is an unlawful assembly. An unlawful assembly can be proved in either of 2 ways. I'm going to talk about that a little bit more in a second. But one of the prongs, one of the theories upon which the people can prove that an unlawful assembly has occurred is by showing that 2 or more persons gathered together to engage in conduct which was violent, boisterous, or tumultuous in nature. Tumultuous meaning that it was reasonably likely to excite terror, disturb the peace of the neighborhood, and words to that effect as you will be instructed by this court when all the arguments are done. Now, Mr. Butchery described circumstances that night where he, from his bedroom window, can see the glow of crosses, or the glow of flames, as the crosses were inflamed. And he came downstairs, and there, he said, were 50 or 60 people, half of whom were children. Others testified, they went to the front of the property, Mr. Butchery did not, that there were a dozen or 15 neighborhood residents up at the front along Cable Canyon, not at the backside of the property from which Mr. Butchery and Mr. Walker had walked towards the glowing flames. He said that half of those 50 or 60 people along his street in Lakeview Terrace were children. Now, these things, when one empathizes and puts themselves in the position of the people who were witnesses, who saw what was happening that night, got to be acknowledged as actions which create lasting emotional scar. Those are the victims. They're not alleged in any portion of the complaint as victims, but those are the real victims that are involved in this case. And the proper presentation of this case includes that type of aspect. It includes the second prong of the unlawful assembly. And again, one must consider what would have befallen Mr. Buttrey and Mr. Walker had they not been stopped by Officer Lopez in time as they walked towards those three burning crosses, men carrying these table legs. This jury has a right and it has a responsibility to protect the residents of this city, this county, and this state. And that is the focus of who the protection extends to in this situation.
It took the jury 7 long days to carefully weigh the First Amendment's right to free speech against a deliberate act of terrorism.
They did return guilty verdicts on almost all of the counts. And most importantly, they returned guilty verdicts on the unlawful assembly count, which was the count that we looked to establish the legal precedent that we felt was so important.